This podcast is about the cases falling under the topic of intention to create legal relations. Recall that there are certain presumptions at play depending on the situation. In family arrangements, there is a presumption that the parties did not intend to create legal relations, whereas there is the opposite presumption in commercial arrangements. In Balfour and Balfour, the plaintiff wife could not accompany the husband on his trip due to health reasons. The husband agreed to give her £30 a month until his return. This agreement was made at the time of good relations, and the wife expected the husband to return in a few months. While the husband was away, the marriage deteriorated, and he refused to pay. The wife commenced proceedings for restitution of conjugal rights. She obtained a decree nisi and an order for alimony. Now, as you're reading through these cases, you will need to make sure that you look up all of these unfamiliar terms because they do come up again and again. In this case, conjugal rights are rights and privileges arising from the marriage relationship. Decree nisi is a provisional court order to terminate the marriage. An alimony is court-ordered allowance that one spouse makes to the other spouse for maintenance and support while the spouses are separated, involved in matrimonial lawsuit, or after they are divorced. Alimony is also known as spousal support or maintenance. In the judgment below, the court found that the husband and wife had contracted as to the extent of the obligation. So the court found that the husband was obligated to support his wife as defined under their agreement. On appeal, however, the court determined that the issue was, is this agreement, which is a domestic agreement, a contract that can be recognized at law, meaning one that can be enforced by the courts? Was there an intention to have this agreement enforceable at law, is another way of looking at it. And the ratio is, there is a presumption that domestic agreements are not governed by legal relations. Quote, in respect of these promises, each house is a domain into which the king's writ does not seek to run and to which his officers do not seek to be admitted. The court said that no contract was established. The parties in domestic contexts do not intend for their agreements to be governed by legal relations. Quote, the promise here was not intended by either party to be attended by legal consequences. End quote. Now, one of the main reasons given for this rule and many other rules, which we will come across, is that it would open the floodgates of litigation if we found it to be the case. So if you had parties in domestic arrangements being able to legally enforce agreements between them, if they could sue each other for non-performance of any obligation, express or implied, then the floodgates would open. Courts would be unable to handle that load. In the case of Rose and Frank, which was about commercial arrangements, the parties had the following arrangement. The plaintiff appellant was to be the exclusive distributor in the US and Canada of the goods, which were paper products, supplied by the first defendant and manufactured by the other defendant. The plaintiff submitted an order which the first defendant refused to fill. The agreement that appointed the plaintiff as the defendant's distributor contained the, quote, honorable pledge clause. This clause said, this arrangement is not entered into, nor is this memorandum written, as a formal or legal agreement, and shall not be subject to legal jurisdiction in the law courts either of the US or England. But it is only a definite expression and record of the purpose and intention of the parties concerned, to which they each honorably pledge themselves with the fullest confidence, based upon past business with each other, that it will be carried through by each of the parties with mutual loyalty and friendly cooperation. The defendants terminated the agreement without notice, and the plaintiff sued. In the judgment below, the judge found that the agreement is enforceable, notwithstanding the honorable pledge clause. The reasons were that the other provisions of the agreement appeared to be binding, and the honorable pledge clause is repugnant to it. Also, the judge found that this clause is contrary to public policy. On appeal, the trial court decision was reversed. The issue on appeal was, is contractual intention presumed in commercial contexts? Another way of saying it is, on what basis can the intention to create legal relations be rebutted? The ratio here is, in business agreements, there is a presumption of intention to create legal relations, as opposed to domestic or social arrangements. This presumption can be rebutted when the parties make clear through their agreement their intention to not create legal relations. The reasons found by the court were primarily relating to freedom of contract. Parties are free to enter or not enter into any agreement. They can put whatever clause they want in their agreement. And so in this case, the Court of Appeal held that the defendants were not required to fulfill the orders they received at the time the agreement was terminated. Since this wasn't a legal agreement, there is no legal remedy for non-delivery. In the case of TD Bank and Lee, this chart here is the corporate transaction chart for the case. We will come back to this. First, some terms. So the definition of a parent and a subsidiary. You will learn in business associations about what a corporation is and its relationship to the different stakeholders. But for now, I just want to mention that at law, a corporation is a separate legal entity. It is a legal person. That means it can sue and it can be sued in its own name. It carries out its own activities. A parent corporation has a controlling interest in its subsidiaries through ownership of more than 51% of the voting shares. A parent corporation is a separate legal person than its subsidiary, just like a parent is a separate legal person than his or her child. If a child does something illegal, the parent cannot be held liable for the child's actions. This case talks about a letter of comfort. What is a letter of comfort? This is when, if you have a subsidiary corporation wanting to borrow money from a bank, the bank will usually look to the parent corporation to guarantee the loan. If the parent is unable to do this, the lender and the parent may agree to a letter of comfort. In this letter, the parent provides assurances regarding its relationship to the subsidiary, and it provides statements about the policy concerning the administration of the subsidiary corporation's affairs. Basically, it means that the parent company is aware of the lending situation and it approves of it. Now, when the subsidiary corporation is unable to repay the loan, the letter of comfort can become a subject of dispute. The lender will usually argue that the letter of comfort is a contractual document which provides the basis for damages in the event of the non-payment of the loan by the subsidiary. The parent will argue, however, that the letter is not a contract and is merely a matter of honor. The parent company is aware of the lending situation and it approves of it. It is not a guarantee that the parent will pay back the loan if the subsidiary is unable to. Back to the chart. In this case, the plaintiff bank wanted to develop a relationship with Plessey, which is a large English corporation. The bank offered to lend money to the defendant, which was a subsidiary of Plessey. Plessey provided the bank with 5 letters of comfort in connection with a series of loans made to Lee. There were various takeovers during that time, and at the time the 5th letter of comfort was provided, General Electric was in control of Plessey. This means that General Electric was the parent corporation at the time. During the relevant time, Lee had borrowed $40 million unsecured funds from the bank. And Lee went into bankruptcy, and the action is now between the bank and General Electric, and the action revolves around one paragraph in the 5th letter of comfort. Quote, "It is our policy that our wholly owned subsidiaries, including Lee Instruments Limited, be managed in such a way as to always be in a position to meet their financial obligations, including repayment of all amounts due under the above facility." The bank brought a contractual claim and a tort claim, both relating in part to paragraph 3 of the letter of comfort. The issues arising from this case are several. 1. Does paragraph 3 of the letter of comfort create a legally binding document? This is a narrow intention issue. Another way you could put it, is a letter of comfort a legally binding agreement or an agreement binding in honor only? This would be putting it more broadly. And a way you could phrase it as an interpretation issue is, what is the correct interpretation of the letters of comfort? Both parties agreed that paragraph 3 contained a representation by Plessey to the bank regarding its policy with respect to the business affairs of Lee. The issue, however, is what was the policy represented to be? The bank says that paragraph 3 is a representation by Plessey that it would manage Lee's affairs in such a way that Lee would always be able to meet its financial obligations to the bank. And so the bank was entitled to rely on this representation unless and until it was given notice of any change of policy. General Electric, however, said that the paragraph was not a representation that Plessey would manage the affairs of Lee. Rather, it represented that it was Plessey's policy that its subsidiaries should manage their own affairs in such a way as to be able to meet their own financial obligations. At trial, the judge dismissed the bank's contract and tort claims, and the bank appealed. And on appeal, the ratio was, unless there is evidence of contrary intention, a letter of comfort does not create a legally binding agreement, which means that a parent company is not responsible for the financial obligations of its subsidiary. Why did the court say that? Well, first, the bank's interpretation of paragraph 3, that Plessey would manage Lee's affairs in such a way that Lee would always be in a position to meet its financial obligations, is inconsistent with the words be managed and would require that additional words be inserted. Now, to really understand this case, we have to look at the relevant background. First, the bank and Plessey were sophisticated commercial entities. Both entities were familiar with letters of comforts. The bank knew that a letter of comfort is not security in the traditional sense. Security being that Plessey would be securing the loan that the bank is granting to Lee. As in, if Lee fails to pay the loan, then the bank could look to Plessey to pay off that obligation. So a letter of comfort is not that. And if both parties are sophisticated commercial entities, they would both know that. Also, another point in the relevant background is that the bank wanted to establish an ongoing relationship with Plessey because Plessey is a very large multinational corporation. Why is this important? Well, if the bank is competing with other banks and other banks are willing to offer the loan without a guarantee, then the appellant bank here would be more than willing to be the lender without a guarantee to secure Plessey's business. So if you look at all of that background information, it helps to inform why the letter of comfort is not going to be a security for the loan that the bank is providing. The process of determining the meaning to be given to the words in a document is governed by the same principles, regardless of whether the processing is engaged in the context of a contract claim and a tort claim. And so as the court is looking at the background, that's going to determine how it looks at the contract and the tort claim. Now, in this case, in this case, this is a commercial relationship, and the normal presumption, therefore, would be that the parties, that is the bank and the parent companies, Plessey and General Electric, intended to create legal relations. That's the presumption. However, the fact of the letter of comfort forces us to reconsider that presumption. As the Court of Appeal states in its reasons, we must view objectively the factual background and the wording of the agreement to determine whether the parties intended to enter a legally binding agreement. We can read the letter of comfort in one of two ways. One, we can regard it as proof that rebuts the presumption, or two, we can regard it as a special exception to the general rule that commercial parties intend to create legal relations. In either case, the result is the same. The case itself does not speak about presumptions, which is why it is not clear which reasoning is preferable.